All right, Steve Palmer here with another edition of Lawyer Talk. As everybody knows, we have tackled all sorts of topics. We've talked to all sorts of guests. And despite the name Lawyer Talk, it is not all that common that I actually talk to other lawyers. But today is an exception. I have Mark Satawa, phenomenal criminal defense lawyer. In fact, Mark does exactly what I do for a living, by and large. But you do it up in Michigan. Mark, how you doing?
Steve, good to be here. Thanks.
Thanks for coming down. So all the way from Michigan here to appear on Lawyer Talk. Let's sort of start at the beginning, man. Introduce yourself.
Well, there's a little bit more to it than that, right? Our relationship goes a little bit deeper than coming down just to say hi on Lawyer Talk.
It wasn't that Lawyer Talk is just that famous that you called me out of the blue and wanted to be on it?
It's on its way up. I mean, you're getting there. The word's spreading fast like wildfire.
All the way to Detroit.
Yes. I'm in my early 50s. I graduated law school in 1992 from Notre Dame Law School. I went to the University of Michigan as an undergrad. I've been practicing law, except for 1 year as a ski bum in 1993 when I took a year off. Had a little thing I had to deal with.
I understand.
A real reset button on life. I've been practicing law since 1992. I started in the Attorney General's office doing civil tax fraud and tax fraud cases. Took a year off, taught skiing and tended bar in Vail. Came back, worked in Wayne County Prosecutor's office for 5 years. That's the county Detroit is in.
You see how you glossed that, though? Like work in the prosecutor's office for 5 years. So you got a prosecutor background.
Yeah, and it's interesting because it was a great job. And I worked with great lawyers. And the experience, of course, I was 6 months in the office, and my first jury trial was about 4 months in the office. It was beanie of a coin box. Somebody busted a payphone back when we had payphones, busted a payphone open for the $13.75 in quarters. My second jury trial was a second-degree murder. And so, it's...
You talk about learning fast, right?
It's baptism by fire. You get the experience is great. The networking, you're meeting all the judges, you're meeting the players in the building.
Well, I think a lot of it, I mean, a couple of things. My dad was a prosecutor in fact, United States attorney for a bit, and he was also a law professor. But he always said this, that being a prosecutor, it's a great place to cut your teeth, start your career as an attorney, no matter where you go, for the reasons you're talking about, right? Because you learn all sorts of stuff. You learn how to file something. You learn who the judges are, what to do in a courtroom. And
in my case in Detroit, it's not like we had a high tech, well-staffed office. I mean, I was, getting my own subpoenas out. I was filing, like you said, filing my own motions, doing my own research, drafting my own pleadings. And I didn't have a secretary. I was my secretary. I didn't have a clerk. I was my clerk. We'd have interns in the summer and stuff like that. But yeah, I mean, it is a full, all-encompassing, indoctrination and plunge into the deep end of practicing law, particularly criminal law.
Which brings me to the next thing my dad always says. But most people stay too long. And that's always been his criticism, is that, and I'm not going to indict everybody who's made a career out of prosecuting cases, but we have all seen the people that have been at the prosecutors too long, where they get maybe even a little grumpy or sort of lose perspective, or it just becomes a job that's mundane and they don't like it, so the discretion that they're granted isn't necessarily exercised even at all.
Two main problems with staying in the prosecutor's office long. Now, I was there for 5 years, and I knew when it was time to go. I mean, it was a light bulb moment, an epiphany, where I was just like, you know what, this job has run its course. It's ready. I'm ready to walk out. Two problems, though. First one is what you just talked about. It's that idea of being a public servant. You're a civil servant. You may have a law degree. You may be a lawyer, but you're still a civil servant, right? You become addicted like crack to that paycheck, to the benefits, to the retirement plan, you become a slave to it. I mean, yep. It's that civil service mentality. Problem one. Problem two, and much more problematic for guys like you and me and what we do for a living, is the sort of righteous indignation that it breeds, that every file, the person is guilty, they deserve to go to prison, that that we're not going to look at these cases and what's going on behind these cases as individuals. There's not people behind them. The person's a father, he's a son, he's a brother, he's a husband, he's a whatever, and quite frankly, like anything else in life, there's two sides to every story. Mistakes get made. Some cases are better than others. And you and I have had conversations as recent as yesterday where we've talked about how, you tell me that you want to put my client in jail for 18 months on a simple gun possession case, but you'll let him have 6 months on a rape?
On a date rape, right. Yeah.
It's that kind of you lose the forest through the individual trees. And you get that righteous indignation you understand, Steve, that trespassing is a crime. And yes, I understand it's a crime, but sure. The question is how should we punish that crime? And does a guy who had a handgun in a car that may have been put there by someone else, does that person need to go to prison for 18 months?
Or even if not by somebody else, right? So where does that, we all understand, and maybe this is part of it that people don't get. Prosecutors have enormous discretion to resolve cases, to recommend sentence, or to not even prosecute at the outset. And if I have found when prosecutors lose that discretion in their career somewhere along the way, most do, and instead just start checking boxes and counting coup or whatever they're doing, or not caring at all, even worse, then that is when we see bad results in the criminal system. I think there's got to be baked into what makes our adversarial system work is that prosecutorial discretion exercised properly.
How many times have you been, and I completely agree with you, by the way, and it's very well said, and quite frankly, the old idea about power corrupts, absolute power corrupts absolutely. The discretion and the power that they wield,
sure.
The power to charge a citizen with a crime, multiple crimes, and not only charging with a crime, but deciding which crime.
Yeah.
Right? I mean, how serious? There's always a scale. Do I charge up here? Do I charge down here? Do I charge in the middle? And like you said, that's based on the discretion that if you lose, that power is going to become a very, very dangerous thing. And so how many times have you, had us that do these things, have been in a conference room with a prosecutor? Sometimes even with a prosecutor and a judge, if the judge is asking you, Steve, why is this case going to trial? And you look at the prosecutor, you look at the judge, and you say, well, because, Judge, my client's innocent. He didn't do it. And they go,
oh, yeah. Oh, come on, Palmer. Yeah.
They laugh at you, and you're like, I wasn't joking.
We're going to get into this because this is part of one of the things I always ask the jury later when we talk about, we're going to talk specifically about some child sex abuse defense because I know you do a lot of it. But one of the things I always say is just give me a show of hands. How many people think actually false allegations happen?
Right.
And you get hands all over the place. False allegations happen. How many think it's happening here right now? It's crickets, right? Because nobody thinks, like every prosecutor, and I'm using some superlatives here, maybe not every prosecutor, because I did say this once on the air, and I had a prosecutor email that says, oh no, I dismissed plenty of child sex abuse cases. And to that individual's credit, I believed him, because he was a good prosecutor. But by and large, no prosecutor, no detective, no hospital staff, or anybody else you would get on one of those kind of cases thinks it's happening in the case they're working on.
100%. Steve, truer words have never been spoken, right? Because it always happens. It happens all the time. It's just not happening right now.
Right. We got this one right for sure.
Every time.
Which by implication means that every other false allegations that's been proven false, either by recantation, DNA, or whatever solid, concrete, believable evidence you might come up with 15 years after the dude's been sitting in prison, that somehow was a more sinister prosecution where they were pursuing some sort of bad motive.
Right. When you look backwards, you can always see these straw men and these red herrings that should have been noticed. But of course, as it's happening, they're never noticed. And the other question to ask a jury, because look, you and I are the same way, Steve, right? I mean, we're regular people. We're fathers. We're husbands. I mean, we have a family. I'm driving down coming down US 23 to come down for the show, and I see a state trooper with a person pulled over. The first thought to my mind isn't, well, I wonder what that person's presumed innocent of, right? It's like right. The first thing I think, I'm a criminal defense lawyer. What do I think? What the hell did that guy do?
What's he do? And then you see another car behind it. Oh, it must be dope. Right?
But it must be something bad. Right.
There's a dog. Right. No way that guy's innocent. Right. And I guess guess you had to make that shift. So this circles right back to it. So after 5 years, now you're sitting on the defense side. How's that happen? Because now you've got to make that shift.
I got to tell you, I loved being a prosecutor. It was a great 5-year experience, and the experience, as I said, was fantastic. But if you asked me to choose, I would choose being a criminal defense attorney over a prosecutor 100 times out of 100. It is, in my opinion, as lawyers, look, if you were to ask me what I want to do for a living, I'd be playing ball, all right? I think we all would, when we were kids, we all grow up thinking, I want to be a ball player. I want to play football. I want to play baseball. Those are the people that love what they do. So I have to get paid to do this. I have no bones about that.
Right.
If I'm going to miss hanging out with my kids all the time, the clients need to pay me to do that job. But as it relates to jobs that you get paid for, it is the best job a lawyer can do, in my opinion. It is the one job referenced in the Constitution of the United States, criminal defense lawyers are, and it's the one job that I feel where you truly, it's Atticus Finch, right? It's Clarence Darrow.
Sure.
It's the one thing where you get to stand up and you get to stand for something, and that something typically is you and I are the one thing standing between, and this is the genius. The genius of our system of government is that there are 12 people that get to stand between you and the tyranny of our government, whatever the government's trying to do to any one individual citizen. So rather than the government just being able to say, hey, Steve, we think you committed a crime, you're going to jail. No. 12 people have to agree unanimously beyond a reasonable doubt that you committed that crime before we get to put you in jail. And you and I have the privilege, the honor, and the thrill, quite frankly, of being the lawyer that stands up to the government, taps the client and say, hey, I got your back, I got this, and get to stand up in front of the government.
I'm with you. No matter who you are, I'm with you.
I'm here, I'm with you, and I will be the one taking the bullets, making the argument, and standing for something. And I think that's great. It's awesome.
Well, a couple of things. First of all, I had and it sort of summarizes what you said, maybe in a nutshell. I had a good friend of mine who does this kind of work too. And he had this interesting way to put it. He said, we do this really for 3 reasons. We do it for our ego, we do it for the cause, and we do it for money. Sometimes one is more important than the other, right? But when you talk about ego, we do get to feel good about helping people, I think. And then the cause, I think you stated it, and I don't think it can be overstated as much as somebody might accuse us of being, overly dramatic or cheesy or whatever, to say that, look, this makes it work. This makes the system work. Even when you've got a guilty guy, how can you defend all those guilty people? I mean, maybe it's overused and oversaid to say, well, because that's what makes the system works. Or makes the system work, but it is true, right? It is.
And it's not only true; it's easy.
Yeah.
Defending guilty people is easy.
Yes.
I get to go home and sleep tonight if my guy's guilty. I mean, if he goes to prison, he goes to prison. He did what he did.
That's funny. That's always my candy
Defend
response
the innocent
too.
people.
Yeah, try that.
That's stressful.
Yeah, try that. Try standing up there with a guy who's charged with a crime that if he loses, he never sees the light of day or he dies. Try that.
Right.
I beg anybody out there to try that. And do it when you know in your heart of hearts that he's innocent. Or at least as much as you could know that. Right?
Correct. Yes,
yeah.
Absolutely. Yeah. Absolutely.
And try to go to bed at night on day one of trial. Try to go to bed at night on the week before trial without thinking about it. And then try to live with it when the jury comes back with the wrong verdict, heaven forbid.
Any trial lawyer who claims he's never lost a case is lying. And any trial lawyer, criminal defense lawyer who says he's never lost a case he should have won is really lying.
Is really lying, right?
And
because we all have.
Correct.
And how that impacts me, and I presume us, and most of us who do this, if not all of us, is really, really hard to quantify. I mean, there are cases I'm sure you have, and certainly I have, that I will never forget. I could tell you the names if I could do it publicly, but I can't. I mean, I could list them. This guy should never have lost this case. This should never have happened. There's one case that became my albatross where the jury came back 15 counts not guilty, 1 count guilty, and then asked me, so when's he get sentenced? I said, well, it just happened.
Right.
What was the sentence?
Life.
Life. Yeah. Well, what do you mean? Well, I mean life.
Well, and they look at it, but we found him not guilty on 13 of the 14. What do you mean he's getting life?
Yeah, life. Yeah, life. Oh, we thought. The horror in their eyes really was a sight to behold. And now that became my albatross. I got it reversed on appeal. I mean, I did hours and hours and hours, maybe years of free work to get that individual out of the mess again in the Court of Appeals, and I was successful.
Child sexual abuse, date rape, campus sexual assault, shaken baby, abusive head trauma, medical child abuse. These cases that I'm known for, that I know you are known for. These are not cases where people get probation.
Right.
Okay.
Right.
And I had one recently, recent within the last 5 years, where, I mean, if you were to ask me the one recent case I tried that I firmly believe the client was innocent, I should have won it. The jury convicted him of first-degree child abuse. It was just an awful case on any number of fronts, including the stunts and the antics of the prosecutor. You do enough of this work to know how often the Supreme Court in any state, but the Supreme Court in this case in Michigan, in your case Ohio, but in this case Michigan, reverses cases because of prosecutorial misconduct. This conviction was
rare bird, to be sure. Right.
Reversed because of prosecutorial misconduct. My client walked out of prison. It was one of the happiest moments of my life, just opposed with one of the worst moments of my life when the jury read that verdict of guilty. And in between there, 3 years of sitting in prison for a crime I don't believe this client committed. Like you said, try to fall asleep.
Right. Every day. And then
with that on your conscience.
Get that guilty verdict, go back to your office, put the box where it belongs, wherever that might be in the office, go
Storage,
home,
right.
And then come in the next day and start returning all the calls you missed and try to do that and concentrate. It is unlike any other profession that way in a lot of ways. But it also comes with a lot of satisfying moments. The problem is, like you said, it's like the highest point and the lowest point. I guess it's no secret that people that do what we do end up with all sorts of their own personal problems, right?
They gamble, they drink, they do drugs, right.
Sure.
Yeah,
right.
you
give all the good stuff to the people you're helping, and then you save the bad for you.
Right.
Well, back to it. So you've been doing criminal defense now the first 5 years were prosecutor and then criminal defense.
Since 1999, so I've just completed my 20th year of practicing criminal defense work.
And I guess I meant to do this earlier, but we'll just do it now. I mean, we met about 10 years ago?
Yeah, and it's a great story, and it's actually had some ups and some actual personal downs for both of us, you more than me. But it was just one of those things where I had a child sexual abuse case. The person hired me. It ended up being charged in Columbus, Ohio. I believe it was out of Guyana, right?
It was Gahanna.
Gahanna, sorry.
And it ended up in Franklin County here in Columbus.
Yeah.
Yep.
And I needed local counsel. I got to Eric through NACDL, National Association of Criminal Defense Lawyers. You were Eric's partner. You and I met, and we hit it off immediately. And quite frankly, even when Eric was still with us, you sort of started replacing Eric and kind of taking a bigger and bigger role in the case as the case went on, because you just had a flair for it. You had a knack for it, like I think I do. And we not only became really good colleagues and a great team on that case, obviously we became friends as well. And that was... And this goes back to sort of my ego part of it, because I do think anybody who does what we do, we got big egos, right? And that comes with big needs at times for our egos. Otherwise we wouldn't do it. It'd be too hard. But Eric passed away in the middle of all that. And I remember a time actually before he passed away, I came back and you guys were working on the case. And I remember thinking to myself, I can't work on that case because we're going to butt heads. It's like we're going to be there. There's too many. Oh, you and I?
Yeah, I remember thinking that we're going to have. It's going to be tough. And then Eric passed away.
Head chefs.
Yeah, too many head chefs in the kitchen,
and no sous chef,
and nobody to keep us either of us in check. Right. But it actually worked out great, and we did get that case resolved, and that was one of those moments where I think both of us felt that guy had no business being charged with crimes.
Well, and it was obviously, in the end, a happy ending. I'll never forget the words that his wife had for us, and they were very genuine. Yep. She was deeply religious and very sincere in her religious beliefs, and She certainly told us that she was going to pray for both of us. And
Yeah.
I think at the time we both felt we needed that.
I could have used it.
Right.
Right.
And I just, it was, like you said, just about any lawyer you're going to work with in a case like this with those kinds of stakes and that kind of, that kind of serious nature and level of case with those kinds of consequences and the stakes being that high, that is, you're going to work with somebody who is your equal, which of course, like you said, means that there's going to be a certain level of butting of heads and too many chiefs, and not enough followers. But that relationship quickly became as good or better than any relationship I've had working with another lawyer.
Well, and I think, dare I give us both a compliment here, is I think we're both able to check that and make the right decisions, whatever they would be, right? If you wanted to do it one way, I wanted to do it a different way. I think we're both able to sort of reevaluate our positions and say, all right, that's the way to go. Now, with that, here's what we're going to do. We're going to take a little bit of break. I know you have worked on lots and lots and lots of big, high-profile cases. I'm going to ask you about a few of them after the break. And then we'll go into some more stuff later on. So
awesome.
We'll be back. All right, back from the break here with Mark Satawa. Now, Mark, I promise we're going to talk about some of the big cases you've worked on, but a couple more introductory things. Now, you've had a national presence, and in fact, you said you reached out to us or my law firm with Eric Yavich back, whenever that was, 10 years ago. And you mentioned the National Association of Criminal Defense Attorneys, and you've been one of those lawyers that I've watched over the years sort of lecture around the country and provide insight to others on everything criminal defense. But you've also had you've focused a lot, I know, on child sex abuse in general, shaken baby, and some other stuff. We're going to talk about that. But there's some other big cases I know you've worked on just from knowing you, as well as the media, that I'd like to ask you about. But let me start by saying this. Why would anybody ever confess to a crime they didn't commit? They must be guilty.
Yeah. Right?
Yeah. I mean, really, how many times you heard that?
Yeah.
And you have experience almost, you can answer the question, I suppose.
Yeah.
So let's start there.
So, the science and the psychology is fascinating, and it probably exceeds the scope of our show today. But the point that we really know is it's hard to pinpoint exactly why they do it. But the one thing we do know for sure is that they do it.
Yes. And I've actually seen you on Netflix.
Yes.
So now that must make you famous, of course. But
yeah,
I mean, not as famous as Lawyer Talk. But,
my kids thought it was great that I was on Netflix, and they, the show has been shown in their high school, and they think it's great, and I've come to their high school to talk about it, So, but I got to tell you, before we get to the Netflix thing, I represented a young man who was 18 years old, developmentally disabled, had the functional IQ of an 8-year-old, and he was arrested for a grisly rape and murder in the city of Detroit. The family hired me. Great people. Down to earth, salt of the earth type folks. And there was a full confession. And I read this confession, Steve, 5 pages long, every question initialed, every answer initialed, not in his handwriting, but initialed, and then signed at the end with graphic details about how he snuck into this young woman's bedroom, through her window, violently sexually assaulted her, strangled her, and killed her. And I'm thinking to myself,
yeah, well, now what?
Now what? Where do we go from here?
Let me put that in context real quick, because you and I understand how this goes. But people go and they are arrested. They are interviewed by police in an interview room where it's usually almost always now video and audio taped, or at least we would hope so. And then often the police will go to the next step and actually write out the questions this individual was asked, write out the answers, or at least a very close approximation to the exact answers, and then have the guy initial it as to say, you're really confessing, right? It's like not just on tape. Now you're really, really, really double secret confessing.
Well, this did not have the tape, either fortunately or unfortunately, I suppose. But, I mean, I was really, really worried about, this confession, as any of us would be representing this young man. And I started looking at it, and I said to myself, this kid's got the functional IQ of an 8-year-old. And, I mean, these answers are, vocabulary and syntax and sentence structure and, just words there's no way he could use. Well, it turns out about a month into the case, we get all the forensics back from the crime lab, and the DNA didn't match. So
he left DNA at the scene, or the killer.
The killer raped this girl, ejaculated, left it inside her. It was sent to the crime lab, and it wasn't him.
Now, I've had cases like this, and maybe not exactly like the one you're describing, and then the answer you get, ironically, is not that your guy might be innocent. He was just there but didn't leave a semen. Right. He still was part of it.
The unindicted co-ejaculator, as Barry Scheck likes to call it.
Yeah, the unindicted co-ejaculator, because there is no way they could have gotten it wrong, right?
Correct.
There is no way they could have gotten it wrong. And this is like the making of a murder we see on, everybody's watched this now, yet they got it wrong.
And I was part of the civil lawsuit against the city of Detroit and the police department, and it was frightening how they got this young man to say what he said. And I knew that right then and there, as if I didn't have this lesson earlier in my legal career, yes, people confess to crimes they didn't commit.
And what shocks me is sort of back to the point I was just making about the unindicted co-ejaculator is the willingness of those in the system, whether they be prosecutors, police, judges, everybody else, to not to simply say, all right, we just made a mistake.
Right.
But rather to come up with some theory that makes it work. And that theory is often tortured, twisted, makes no sense whatsoever. If you came to that theory at the outset on the defense side, you'd be laughed out of a courtroom.
Of course you would.
Right? But they're using it against you
right.
on the prosecution side. Tell us about the Netflix case.
So this is a perfect example of what you're talking about, like why does it happen? And, you and I both know, doing this work, that I suppose the why is police are a lot better at interviewing suspects who are scared and lonely and anxious and nervous and freaked out and all those other things, frequently because a loved one or a family member has been the victim of a crime, if not dead, and they have a technique that they go to school for.
Yeah, the Reed technique.
Reed and Imbaugh wrote a book, and these police officers, these detectives, go to the Reed method of interrogation, where they teach them.
Which, by the way, is old. Right?
Oh, yeah, it's like 20, 30 years old now, right?
I mean, so the psychologist, and you've worked with them too, and I know you have because of the cases you're talking about. You talk to the psychologist who assess false confessions. I mean, the Reed technique will get you a confession. For sure, or not for sure.
But the statistics are overwhelming that it works, right?
But it only works to the extent that you believe it, right? It'll get you a confession, but it may not be true, right? That's the problem.
Well, in addition to that, it gets you a confession. Now, whether that's really what happened or not, like you said, we don't know. But there's a reason it works, and it preys on every vulnerability that these scared, lonely, freaked out, overcome with grief people, that every one of those emotions that they're going through. And it's a targeted, we're going to break you down psychologically. We are going to lie to you, right? Which was part of the Reed technique. They can lie to you.
No rules.
No rules. We can lie to you. We can misrepresent what evidence we have. We can tell you you're guilty. We can tell you we have 5 eyewitnesses. And then at the very, very end, after we've broken you down and we've cut off every possible escape route, we throw you the life preserver. Now, Steve, look. We understand you didn't mean to kill the person. It was an accident. We understand you didn't mean to shoot the person. The gun went off when you were cleaning it. We don't, whatever.
Whatever.
And
with the implication that maybe even get to go home today. Right.
Right.
As opposed to spend the next 35 or 40 years in prison.
So the Netflix show, and again, I know we're not using names. The name is in the show. In fact, she's interviewed in the show. I still won't use her name, but this is a mother who had a horrific relationship with her teenage daughter, and the kind of teenage daughter-mother relationship that they write books about and do shows and movies. And they were going on a vacation in a couple of days, and she was just refusing to go, and it caused this. Just the house was turned upside down, and the mom was frustrated and was famously as quoted as saying something along the lines of, oh my God, I hate her. I wish she would, I wish she'd go away or what. I mean, she never said I want to kill her. I wish she were dead, but I hate her. I wish she would go away. Whatever. And so she left one morning, went shopping with her best friend. The mother did. They finally track her down. This was right in the beginning of cell phones. I think she did have a cell phone. They tell her that her house is on fire. She comes home, her house is burnt to the ground, and she learns that her daughter was in the house when it burnt up. So in that state, with the fire department and EMTs bringing the charred remains of her dead daughter out of the house, she's arrested 12 hours later.
And interviewed.
For 48 straight hours.
48 hours.
With minimal breaks. She is lied to. She's told she failed a polygraph. She's told that her fingerprints are found on evidence that doesn't exist. She's told that a test for accelerants on her hands and her body and her clothing has come back positive. All these things are false.
Just flat out fabricated. And I think a lot of people might be surprised to hear that that's perfectly legitimate if you follow the Reed technique and you follow what the police are permitted to do. I mean, they're like, well, they can't lie to me, can they? It was like, oh yeah, and they do.
In this context, this woman, if you listen to the tapes and this interview, as you pointed out earlier, was video and audio taped. In this context, the police officer finally says, look, client, and she has said she didn't do this 150 different times.
And I imagine what I would do too. I would write down every time, every second, every moment she said I didn't do it.
Well, are you sure you didn't do it? I didn't do it. What about this? I told you I didn't do it. Well, is this a possibility? I told you I didn't do it. Well, could this be? I didn't do it. And then in this context, they finally say to her, look, client, what if you just don't remember doing it? And her answer is, well, if I don't remember doing it, then of course I don't remember doing it.
Sure. And there's no good answer to that question.
Right. Yeah. And then they say, well, what if people can do amazing things when they're sleepwalking. What if you were sleeping at the time, or what if you were, somehow, not acting voluntarily of your own volition, and I didn't do it, and well, if you were asleep, if you were intoxicated, if you weren't, clear-minded, what if you dreamt that you did it? And again, I didn't do it. Well, if you dreamt that you did it, how would you do it?
Right.
And
how would you do it? Right.
That's the questions she started answering. Okay, well, if you want me to imagine how I would have done it if I had done this, and she starts telling them. And that's the confession that was played to the jury at this woman's trial in conjunction with an arson investigator. Of course, arson investigation is one of the junkest of all junk science.
I mean, if we just talk about what it is, if you don't know how the fire started, it's arson.
Right.
Right. That is arson science in a nutshell.
It was one father passing to his son, and that son passing to his son, because they were all firemen. Well, you see those burn patterns? That's called stippling. And every time you see stippling,
there must have been an
there was
accelerant
arson,
that we can't find.
And this
right?
was accepted as gospel. In fact, if you listen to the testimony of this arson investigator in this trial and the prosecutor's opening statement and closing, he wrote the Bible, literally the gospel, the Bible of arson investigation, and it was accepted as gospel until the United States government had a bunch of track houses that they sold to fire departments to do. I don't know, something called scientific experiments.
Sure, right. Well, let's check.
And they did. They started some of these track houses on fire with accelerants, without accelerants, using quote unquote forced sparks and natural causes, and then arson. And guess what? The burn patterns reflected absolutely no correlation to the way the arson was, the way the fire was started. There was no direct connection between.
And this happens in so many contexts in what we do. And we're going to talk
hair, tires, footprints,
everything, right? And you get this notion. I actually heard it was in the context of a child. I was talking to a child abuse psychologist who was talking about forensic interviews. And the point is, when people with authority make these assertions and call it their opinion and call it science, often there's no peer review whatsoever.
None.
It's just accepted.
I know it when I see it.
And what you're talking about.
How do you cross-examine that?
Right. I know it. I'm right.
501 talk. I know that's a devil's symbol. Well, how do you know it's a devil's symbol? Well, I can tell. Look at it.
Right. Look at it. I know. I'm trained.
Right.
Exactly. Yeah, I'm trained.
Trained by who? Well, myself and people like me. Oh, well.
Then it's repeated and repeated. And as we'll talk about in the next segment, that resulted in hundreds of false child abuse convictions because of stuff like that. It was just accepted until all of a sudden, like the FBI decided to do some actual peer review of the science to, dare I say, follow the scientific method, not to start with the presumption that it's true, but rather the presumption that it's not.
The true scientific method requires people to start with a hypothesis and try to disprove it.
Yes.
And a single negative experiment disproves your hypothesis.
Go back to the beginning.
The repeat of anecdote is not data.
Yes.
Or
worse yet, people cherry pick the data, right? They'll find the
confirmation.
repeat of
cherry picked anecdote is certainly not data.
Yeah, and they'll it's confirmation bias. This is true, so we're gonna repeat this until it happens the way we say it happens, and then presume that the exception is the rule, and throw out all the other ones where it wasn't
based
consistent.
on nothing but anecdotal proof.
Yes,
we've seen this happen 10 times, 100 times, 1,000 times. It could be 1,000,000 times. Quite frankly, you and I could do an experiment. The floor in your studio, is it round or flat? It's flat. If we were to walk up onto the street on High Street, is the ground round or flat? It's flat. If we were to walk all over Ohio and then into Michigan and in Indiana and Illinois, we could do this experiment 10 million times. We would get results that the world is flat. So how do we know that the world isn't flat? Well, we have one experiment. We put people up into space. They looked back at the world and we saw that it's round.
Well, sure. And even more before that, there were all sorts of reasons why the really smart dudes back in history could prove it, right? I mean, things like the ship's mast sort of dipping down over the horizon instead of just falling off, right? I mean, but nobody wanted to accept it. And that's a great example because everybody believed it, right? Everybody believed it.
How did you get an ulcer? For years, medical science told us it was because of stress. It has nothing to do with stress.
Yeah.
It's a bacteria. There's a bacteria that causes the two Australian medical doctors and researchers got the Nobel Prize in medicine a few years ago because they discovered that it's not stress. It's a bacteria.
In back to confessions, it's interesting because I have actually talked to and I've been to seminars by folks who really understand the psychological behavior of those being interrogated. And it's not the Reed method that works. I mean, there are things you look for. And what's interesting about your story is the primary thing you expect innocent people to do is deny it immediately. Immediately. So if I say, Mark, you murdered your wife, you're going to say, no, I did not.
Right.
And if by and large, statistically, if that is your first response, it's more often than not that you're not lying. Now, if you've given an ambivalent response like, well, some explanation, why would I ever do that?
Well, right, that's the classic. Instead of saying no, well, what proof do you have of that, or why would I do something like that?
Too much going for me. I would never kill my wife.
Right.
All right, well, now that's like 2 points in the wrong direction immediately.
Exactly.
The Reed technique incorporates none of that. In fact, it would take your initial response and say that's normal. Now you have to attack it and go after it and convince them that they're wrong.
And I'll tell you, as I was saying in Karen's case, her confession, and I wasn't the trial lawyer, I was the lawyer that handled the appeal. Her confession with this arson investigation, science, and she got convicted on nothing. Sentenced to the rest of her life in prison on nothing. And it's again one of those instances where it exposes the real fundamental flaws in the criminal justice system when we go so far to convict the guilty that the net goes too wide and we start convicting the innocent. And that's why you and I are...
That's why we're employed, right? That's why we do what we do. But then it goes back to the question we ask is like, who in that case do you feel really felt that they were pursuing the wrong person or the wrong case?
No one.
No one. not a one. But afterwards, everybody's willing to say, "Oh, we made a mistake on that one," right? Or maybe they're not. Who knows? Sometimes they ride it to the grave. But and there's always at least one who says, "No, I'm sure she did it."
And the righteous indignation, it's always a scary, scary thing. And you know, sometimes when you're doing these cases, the bigger they get, the bigger the stakes, the more invested the government or the state gets, and they just will never back down. Like you said, they become invested. You're pot committed, and we're just not going to go that way when we believe we have our man, we are men. We believe we know what happened here, and these people did it.
And it's almost like I've tried to describe it this way to people before. We've all argued with, sometimes it's even our spouse or our children, where you just know 100% that they're wrong. And not to be arrogant about it, it's not that. It's just that they're wrong. They're making a mistake in something. Maybe they thought it was on Tuesday, but you pulled out the calendar, really it was Wednesday. There is an ability of people to go to the grave saying, no, I was right. And the frustration that you feel when you're trying to convince somebody that they're wrong is sort of what we feel all the time, except it's life stakes. It's high stakes, and it's not about winning an argument at home in the kitchen. It's about this person going to prison for the rest of their life, or dying even worse. A
really good example of that, I know before we started here, we were talking about the case that I did in Michigan involving the Michigan militia, which became known as the Hatari case a few years back. And, they had a confidential informant tell the FBI, hey, look, there's a bunch of guys running around in the woods dressed up in camo, carrying AR-15s, and there's like 10 of them. And, they get drunk around a campfire and they start saying stuff. And what kind of stuff are they saying? Or they're saying stuff like, well, we should take over the government. We should start an open rebellion against the government. And how would we do that? Oh, I don't know. I got an idea. Well, what's your idea, Bob? Well, my idea, Steve, is to, what if we were to murder a couple of cops and then wait for cops from all over the country to come to the funeral, and then we were to shoot up that funeral, and we were to blame whomever, whatever group, and basically start an open rebellion. And so this confidential informant comes and tells the FBI. The FBI puts an undercover into the group, and this undercover invests 18 months and millions, and I do mean millions of taxpayer money investigating 10 people who are about as harmless to national security.
Dudes drinking beer in the woods, right? Camo, right?
Right,
yeah.
Exactly.
Right.
This is Billy Bob and Joe Bob hunting deer. Except that there was the one. It was great because we played this video as part of the defense team, and there was 10 of us on the defense team. And there's one guy has an AR-15, and they're doing maneuvers, right? And they're trying these military maneuvers, and of course they would videotape it because they wanted to. Critique themselves and the same way you videotape a football game, right? And also look at the film. And this person trips and falls, and the muzzle of their AR-15 goes into the dirt. So they like bang it, and then they pick it up and they look at it like this, like
it's all on tape. Right?
All on tape as the guy looks down the barrel of a loaded AR-15, and you're like, yes, this is the paramilitary group, and I'll never forget the charge with seditious conspiracy. So, of course, sedition in and of itself is a conspiracy, right? It's a conspiracy to overthrow the government.
Sure.
So they were charged with conspiracy to overthrow the United States government. 10 yahoos in the woods drinking beer and running around with AR-15s. It was the biggest offense to everything that we stand for as lawyers, right? Freedom of assembly, who you get to hang out with. Freedom of speech, while you're hanging out with them, what you get to say. The Second Amendment right to own firearms as you are assembling with your friends or whoever and exercising your free speech rights to criticize the government of the United States. Do I get to own a gun while doing those things, right? This is freedom of religion because they were a religious group that had a lot of religious imagery in their
Sure.
group. And that was my Clarence Darrow moment where I get to stand up in front of a jury in the United States in federal court in front of a judge who was a fantastic trial judge, really, really got it, and make an argument that you really felt like, hey, this is Clarence Darrow standing up and talking about not just whether or not these people did it or not, but bigger ideas, the First Amendment, freedom of assembly, freedom of religion, freedom of speech, the Second Amendment, freedom of own gun, real principles, the principles that this country was founded under. And the thing that drove that prosecution was the amount of money and the amount of time that they had invested investigating these guys, and the government would just not admit that they were wrong.
And I would posit one more thing. You've got an underlying message to the speech that they were using, or the content of the speech they were using, that was unpopular, right?
It was offensive.
Yeah, people don't like the militia, and at that particular time, that was getting a lot of like, oh, these people are dangerous, and this, and there was a cause behind it that, for one reason or another, gave the people deciding to prosecute a green light to go do it, irrespective of the obvious problems with the case. And maybe this is a good lesson of what's going on right now. It's like, as soon as you start regulating and prosecuting content of speech, we end up in big trouble. But with that, we're gonna take another break. We're gonna come back. We're gonna talk some more about really what the meat and potatoes of what you and I like to do, and some of the problems we see with it and how to handle those. So we'll be back here in a bit. All right, back from the break. Mark, we're going to get to some stuff here about our perception on different types of cases and some of the problems, but I realized I never asked you about the militia case and how it ended up.
So after a 3-month trial.
So 3 months, let's put that in perspective, 90 days.
Of course, you're not a trial on the
days.
weekend, but yeah. I mean, probably whatever that is, probably 40 trial days, whatever that is. I mean, 50. I mean,
now other lawyers out there will appreciate that, but if you don't do this for a living, let me just give a little bit of insight. That is every workday for 3 months spent on one case, and at the same time, we are running a complete law practice that has lots of other cases and lots of other needs and people with needs. It is incredibly taxing mentally, physically, and financially to be in trial for that time frame. So I just wanted to put that in perspective. People hear that, 3-month trial. It's like when you're the lawyer doing it, it is a mother of a chore to do that.
Yeah. I had one about a year after that was 6 months, and it takes a lot out of you.
Yeah. So anyway, after 3 months in trial,
the government rested, and we filed what is commonly in federal court called a Rule 29 motion for acquittal, which is where you ask the judge to say, "Hey, judge, there's not even enough evidence for you to continue the case at this point. You shouldn't ask the defense to put on a defense. You shouldn't even send this case to a jury. There's not enough evidence for the case to even be considered by a jury. You should enter a directed verdict of acquittal in favor of the defendants." And we had a few days of argument about that. And I'll never forget my argument and the argument of co-counsel. It was a incredibly talented defense team. Just really, really good, dedicated lawyers. And the judge granted the Rule 29 acquittals, and the guys walked out of this, after being in custody for 3 years during the pendency of this case, walked out of federal court. My guy, by the way, former Marine, fought in both wars in Iraq, decorated not just veteran of the Marines, but combat veteran of the Marines, locked up for 3 years because he wanted to run around in the woods and badmouth the United States government because he didn't like the way it was going.
That's an incredible story. And just to put some perspective on this, Rule 29s do not happen.
Never.
Often. I mean, I've had a few, but in the context you're talking about, huge high publicity case, a lot of government financial investment in it, and all the reasons, all the trappings to give the judge an opportunity to say, you know what, I'm not going to get involved in this one, let the jury decide it. You get a judge who does the right thing and brooms it.
She is an incredible judge. She's principled, she's very down the middle, calls fair balls and strikes, and deserves, like you said, Steve, 1,000,000 points of credit for doing the right thing and having the courage and the guts to stand up to the government in this ridiculous prosecution and do the right thing and send those guys home and acquit them.
Well, this is my time to pivot here a little bit because you mentioned something. You had a really talented defense team. Now, you've been doing this, what's your year count now?
20.
So 20 years of this. And I'm 24 or whatever it is doing defense work, and you had more time in the so it's a long time of
50 years together, I guess.
Yeah, 50 years together. I have seen some changes. I have seen both good and bad changes in the law practice. And I'm going to talk to you specifically about the kind of case that you and I first met on, and then sort of dovetail other things with it. But child sex abuse cases particularly, I have found, say where somebody is charged with abusing sexually a stepdaughter or stepchild or a grandpa
niece,
or
neighbor, whatever.
Yeah,
right.
whatever it is. They just have this particular connotation to them that in Ohio, we're not allowed to specialize. I can't say I'm a specialist in child sex abuse.
Yeah, we can't either, yeah.
But I have found that by and large, the art of defending those types of cases is declining. And I'm bringing this up to you because this is one, how we met, and two, you're incredibly skilled in those areas. And I just want to get your perspective on it.
Well, so you and I have always talked about this, Steve, and you know my perspective is very simple, and that is that a child sexual abuse case is as different from a property embezzlement theft case as a property embezzlement theft case is different from bankruptcy. It is a totally different animal. You either do those cases or you do not do those cases. And there are some very, very talented criminal lawyers in Michigan. I'm sure you could say the same thing about Ohio, where if I was charged with stealing $1 million from my employer, or selling drugs, or trafficking guns, they would be great choices. But if you are not hiring a person who does sexual assault, sex crimes defense, and by that I mean as a regular, large percentage of their practice, at least 50%, you are not hiring the right lawyer. It's that simple.
We talked about this earlier, sort of as we were just bantering back and forth. It's like, the lawyers you're talking about, great lawyers, great trial lawyers at times, may not be equipped to handle these types of cases. But if you looked at what they did after, say, a guilty verdict, there'd be a list of things that they did with boxes next to them. You could check every single box.
They gave their standard opening, right? They cross-examined the victim. They gave their standard closing. I mean, they did right out of their playbook, right?
Yeah.
Criminal defense 101.
And as we discussed before, it's like the problem is the boxes they need to check aren't even on the paper. Yeah, they don't. Right. They didn't know what they weren't doing. Right. That's the problem with these types of cases. And dare I take it a step farther? There's a lot of, or there are a lot of attorneys now who are just saying, I'm doing criminal defense, and I think it's really easy in this day and age to do that. I had a mentor who was argued in the Supreme Court, known as one of the best ever. And I think you did too. You had somebody like that. And, I learned the ropes in the trenches, doing it the hard way incrementally. And in this day and age, it's all too easy just to say, I do child sex abuse cases without having done one. In theory, it's, like you said, opening statement, cross-examine, do your best with this. You got science, et cetera, but you can deal with that. There's so much more that goes into it, and people don't even know what they're not doing. And I'm going to ask you a little bit. Give me some thoughts on it.
Well, first of all, I anytime I have this conversation with anyone, and I've said this to you before, I'm always reminded of the Jim Mora quote when he was the coach of the Saints, and these reporters are grilling him about football, and he was like, "You guys don't. It's not that you don't know. It's that you don't know that you don't know." So, like you were saying, these lawyers that you're talking about, that it's not the problem isn't that they don't know that these cases are different and that you need a different playbook where there are a different set of boxes to check. And those boxes are numerous, and I'll talk about that in a second. But the real danger is that they don't know that.
Sure. So
because they do this with full confidence. This is how I do all my cases.
And successfully, probably,
Correct.
By and large. Socrates, who was the smartest guy because he knew what he didn't know. I mean, that's very insightful to know what you don't know. And it would be easy for me in my criminal practice if somebody came to me with a complicated contract problem. I would say, well, I don't really do that. I'm going to call up so-and-so over down the street.
Yeah, but how hard could it be, Steve? Why don't you just do it? It's guy has a check for $5,000 for you to help this problem. Isn't that how these people think?
And that's how it works, right? But it's easy to do that in the context of a totally different practice area. But this is sort of a sideways shift to the criminal practice area. It sort of connects in a lot of ways.
It is and it isn't. Yeah. And first of all, the first reason I'm convinced that they're different is because I think you and I can stand up in front of a jury, and if I'm representing Steve, and Steve is accused of embezzling the money from the owner of this building, and I could stand up and I can give a reasonable, believable, buyable defense to the jury that, look, maybe Steve did it, maybe he didn't, but you know what didn't happen? The government didn't prove it beyond a reasonable doubt, right? Beyond a reasonable doubt is a theory of defense in just about any criminal case, including, I would argue, homicide.
Sure. Where
it's not a theory of defense is these cases.
You got to be innocent.
Yeah.
Right.
No, Nancy, soccer mom doesn't go home to talk to Betty, hockey mom, and say, Betty, that jury, that jury duty was fascinating. Oh, what kind of case did you have? Oh, we had a person charged with child molestation. He was molesting his niece over a 2-year period. Oh my God, that's terrible.
What a dirtbag.
What happened?
Yeah.
Well, of course, yeah. What happened? Oh, we found him not guilty. You let a child molester go? How could you do that? Well, I wasn't convinced beyond a reasonable doubt.
Right, yeah, I'm sure that happens all the time.
That's not what happens.
I had a case.
They have to say to Betty, I don't think the guy did it. I think he's innocent. That's what they have to be able to say.
That's what they have to be able to say, and that is a fundamental difference between this and regular criminal practice.
What do you always like to call it? A paradigm shift.
It's a paradigm, yeah. There's a little shift. I had a case where a witness was a victim, and that witness said she was sure that she had the right assailant because a tree branch broke through the window, and out of the tree branch dropped a fairy. And the fairy woke her up in the middle of the night and said, "This person is the one who stole from you." If I took those facts into a courtroom, or a prosecutor took those facts into a courtroom, it would be laughed out summarily. But these are actual facts, except it was a child sex abuse case. And
the victim was a kid.
The victim was a kid.
Right.
In her bedroom. And in fact did say that the tree broke through and a fairy dropped out, and that's how I'm so sure that Uncle Bob did it. And nobody thought twice about it. And I sat here in my conference room scratching my head on this, on what to say and what to do with it. And it finally dawned on me, sometimes we just got to call it like we see it. And it dawned on me that in any other context, this is total pure nonsense.
Correct.
So why here, why now do we have a legitimate's not the right word, an actual prosecution going forward where somebody's going to lose their life, literally, for the rest of their life they spend behind bars?
Larry Nassar, the wrestling coach at Ohio State, Harvey Weinstein, Kevin Spacey, Bill Cosby. That's why.
Yeah.
Right? Hashtag Me Too. That's why.
Yeah. And here's the distinction that you and I know are able to make, and I pray that everybody else is too. I'm the first person to say there are awful, horrible people who rape women, who molest children, who kill people in the same vein. I mean, horrible people. But there's also false accusations all the time. And we can't just, because of the nature of what the crime happens to be, believe it in a way that we wouldn't in any other type of case.
Remember how, like, the what happened to House of Cards? The groundswell of negative publicity and negative attention Kevin Spacey got. Well, it turns out that at least one of the accusations was total BS.
Yes.
And if we have not learned our lesson from the Scarsboro 5 or 9 rather, from the Duke lacrosse team, if we continue to forget the lessons of history, we are of course doomed to repeat it. And these cases, they have a groundswell of popular support. They are in many ways politically correct in terms of their in terms of the way the government looks at them. We have laws that you and I have discussed before that are turning these cases on their head, where it's almost like you do have to go into a courtroom and prove your innocence, because the deck is so stacked against you. The 404B evidence that is allowed in, the other acts evidence that is allowed in, the propensity evidence that is allowed in, the syndrome evidence that's allowed in, child sexual abuse accommodation syndrome that's allowed in. Like you said, if someone said to a prosecutor in an embezzlement case, I think there was an embezzlement. I'm pretty sure it happened. I think it was Steve that did it. And I'm not sure when it happened or how it happened, but I woke up the next day and the money was gone, and I just felt weird, like something bad had happened to me when the person stole my money. They would laugh at that.
Yeah, anybody would. Anybody would. But if you just supplant child sex abuse for embezzlement, now you're in court. Now you're in a courtroom with hopefully somebody like you to defend him. Because here's the problem. The standard stuff that people would do to defend a case, as we're saying, do not apply. You used a ton of terms right there that I would say are terms of art.
You said to me that somebody says to you, like, well, Steve, I'm interviewing you and I'm interviewing these two other lawyers. Well, yeah, that's great. Educated clients are my best clients because I know that I stand up favorably against people doing research. You know what I want you to do? I want you to ask your that other lawyer, ask him about the forensic interviewing protocol. Ask him what he knows about it.
Yeah.
Ask him who his expert is.
Which is another huge problem, right? Because there's a Rolodex that we have, and there are experts out there, but they're not willing just to pick up the phone and help anybody out. But they certainly have no expert, nor do they know they need one.
That's the problem. They don't even know they need the expert.
Right.
What do you need to do to combat these cases? You need to start by knowing that you have to put on a defense.
Yes.
That your client in 90% of the cases is going to have to waive his right to remain silent and testify, which means he's going to be able to have to give a direct, and he's going to have to be able to survive a cross-examination. And he's going to have to look at the jury the way I'm looking at you, and he's going to have to say, I didn't do this. All right, and then you need to supplant that. How do you supplant that? Any way you can. Every case is obviously different, but sometimes you need a medical testimony. This girl claims that she's 6 years old and she was violently sexually assaulted, but there's no physical findings.
Now, here's what's interesting. If I just ask somebody off the street, and maybe not everybody, but there's a large part of the population that has been somewhat brainwashed by this, where if I said to you, this little girl's hymen is still intact, you get the standard answer I do out of prosecutors, out of therapists, out of caseworkers. Well,
that's not indicative of anything.
That's not indicative of anything. Which
actually, it's diagnostic is the word, right?
Or diagnostic.
That's not diagnostic of anything. Right?
So it doesn't always mean, all right, well, 99.99% of the time, if somebody has been raped the way they said they were raped in this case, you wouldn't expect that, right? But they're not willing to look at it in the other way. Or
of course, girls tear their hymen getting on a bike. Right. But this violent sexual assault they're going to claim is right.
Just happen to be 1 in a million where this person, this adult male, didn't do anything to this little girl's hymen. Now, I know we're talking graphic stuff here, but this is the stuff that people accept. And I've even heard other attorneys who are on the defense side accept it, where I'll get called, and I'm sure you have too. There was a forensic interview. And by forensic interview, what we're talking about is a kid in a room with somebody who is ostensibly trained to ask questions.
Well, at least supposed to be trained.
To be trained. And they ask a child questions and they get responses. And presumably they get an allegation and there's a prosecution premised on it. And I've had people bring in interviews and put the tape in, stick the DVD in, whatever it would be. And they say, oh man, this is a horrible case. It is very believable. We're in trouble. And then I watch the interview and I say to myself, well, there's all sorts of problems.
There's
here.
No alternative hypothesis testing.
Right.
There are leading questions. The interviewer suggests and introduces topics. The interviewer suggests and introduces the idea of abuse or sexual assault. All four of these things, by the way, are things that are strictly forbidden by the protocol.
Yes, and this is not just defense attorney malarkey.
No.
These are psychologists, by and large, who are looking to prosecute people, have done studies on this stuff, and these things matter. And when those protocols are violated, it means that you are creating a perfect culture for a false allegation. And people get prosecuted on that all the time. And again, back to the point, their attorneys don't know it. And that's where I pick up the phone and I call a psychologist. I call Mark Satawa and say, look at this with me. I mean, I firmly believe, and I've said this, I mean, I've been doing this 25 years, I guess, and I still get other opinions, other help from everybody I can on these cases, because I firmly believe that a team of qualified attorneys, experts, and investigators is absolutely necessary.
And you know, Steve, the key word you use there is team, right? You know, how many times have you and I both talked about the idea of hiring a former prosecutor to cross-examine our client? How many times have you and I done a mock trial where, I know the case you and I met on, you know, we brought in a national jury consultant. We paid students to come in and sit as jurors. We videotaped the mock trial. I played the prosecutor, you played the defense lawyer, or vice versa. I don't even remember. It's been 10 years, but you know, we did all of that. There are things that you can do to try and flip the script to turn these cases back in your favor, but they don't start in your favor. The moment they read that indictment, the moment they read that felony information, the moment they read the charging document to the jury that Steve Palmer or Mark Satawa is charged with criminal sexual conduct in the first degree, or whatever the same offense is called in Ohio, those jurors are like, this guy molested a kid?
And we know that because you and I have done focus groups together where the first thing we write, rape child.
Right.
And the reaction you get out of anybody without knowing any more than that is dirtbag, scum, horrible, castrate. I mean, just do it.
I think that is of all the things we do, look, experts are critical. You need an expert in the forensic interviewing protocol. You need an expert if they're going to talk about child sexual abuse accommodation syndrome. You need an expert in it. You need a medical expert if there are any kind of medical findings. You may need a DNA expert. You know, there's the list of experts is limitless. You may need a nurse. You may need a sexual assault nurse examiner working for you. It's limitless. You know, you need to prepare your client for direct and cross. You need to interview witnesses that can talk about the relationship between your client and the kid who's claiming the sexual abuse, and give them positive examples of when this just could not have been happening. You need to dismantle their case every possible way you can. But I am convinced, and I think you are too, that the most unique and important part of our trial preparation, you do it, I do it, and I know we do it a lot together, we help each other out, and that is that mock trial focus group process where we bring people in, we get out a whiteboard and markers or Post-its, and we start writing. And it is a magical process, because at the end of that, and it typically takes all day, I mean, it's a 6-hour session.
It's exhausting.
It's completely exhausting.
Yeah,
and at the end of that process, you and I have never failed to look at each other and say, that's the key to the case.
And we may have known about it, but it wasn't at the top of the list yet. And we are then able to change our direction if we need to, or stay on the same direction if we're on it, but at least assess and reassess with a proper study of the case, with proper feedback of the case. And really, that focus group, you taught me that, and there is no substitute for that I know of.
It's failure to do it. I would go so far as to almost say it's malpractice at this point, knowing what it provides me. And I would never go to trial on a case of this magnitude without doing it at this point. You and I are completely on the same page about that. And I'll tell you, Steve, that ultimately you must find, this is a kid. It's a kid coming to the court and on a witness stand and testifying that somebody sexually assaulted them. And you have to identify the emotional hot buttons to the extent they exist, both good and bad for your case. Bad because you have to address them, good because you have to emphasize them. And if you don't, you're really putting your client in a really, really difficult position. And here's the other thing. People ask you, I'm sure they ask me, they ask us, like, you're an expert in this kind of stuff. Like, isn't it true that sexual assault is the most underreported crime? And it is. It is the most unreported crime. But you know what it also is? By overwhelming statistical evidence.
I know the answer, but I'm going to let you take it.
It's the most overreported crime.
Yes. More false accusations, at least even in my non-empirical study of my practice over the years, I find more people falsely accused in this realm than any other.
And of course, there's a reason for that.
Yeah.
Because there's always a question as to whether the crime itself even occurred. In an embezzlement case, your law firm either lost $1 million or it didn't. And if it didn't lose $1 million, you can't go to the police and say I lost $1 million because it's in the bank. It's there. In a homicide case, there's either a dead body or there isn't.
Right.
All right. In an assault, there either is injuries or what lawyers in law school call the corpus or the corpus delicti of a crime exists independent of the testimony.
Right.
There is a harm, there is a crime that exists. It is the one case. There are a few others, child abuse and others.
We could come up with some others.
But it's the one case where the corpus of the crime has to be established by the victim before the victim even starts to talk about who did it, how they did it, etc. And it almost logically follows that, of course, it would be the most overreported crime.
Well, there's good news here, and there's lots more we could talk about, and I'm sure we will at some point, perhaps again in the future. But the good news here is that there are people like you who go around and defend these cases and can help. I know I have been consulted on these types of cases. You are regularly consulted on these types of cases. You've actually traveled all over the country to work on these types of cases, and you've made a practice of it.
Both as a consultant or actually being the lawyer. I mean, I've done cases in Atlanta and Illinois and Ohio and a lot of points in between, but I also get hired to be a consultant to help other lawyers prepare the cases. And
I've done it with you. And
right.
Look, I've got a big ego. I said it from the outset. Right? I wouldn't do this if I didn't have a big ego and the need to be the guy on Front Street. We have to check our egos. Even you, even me, even if you've done lots of these, I urge everybody to get some help, a second pair of eyes, preferably a second pair of eyes who has experience, who knows what they're doing, hopefully more even than I would know, and can offer insight that I'm missing. Because again, we were talking about people's lives and sort of the core of our being. This is what we do. It's why the system exists. So
I tell potential clients, I'm not the only lawyer in Michigan that can do this, all right? But there's not a lot of us. There's 5 to 10 of us. And if you're interviewing anyone besides the 5 to 10 of us, you're not hiring the tip of the pyramid. You're not hiring the best. And I'm sure the same can be true of you in Ohio. That
Sure.
You're not the only one, but there's not a lot of you.
It's a short list.
Right.
Well, if they want to get Mark Satawa, tell us how we reach Mark Satawa up in Michigan.
So 248-356-8320 is the office phone number.
See, I love it. Criminal defense lawyers, we still give our phone numbers out because people need to make a call and get us, right?
Right.
It's like I was thinking, all right, here we go. Here's this webpage or whatever. But no, you give your phone number. I love it.
Well, and the funny thing is the webpage is so easy to remember. The webpage is protectingyourfuture.info. So, I mean, that should have rolled off the tongue, right? Protectingyourfuture.info. The email address, mark@satawalaw, SATAWA, But again, it's funny how we are so programmed. And it's a really good point. We've been talking for an hour now. And at the end, we come up with this thing where we're talking about how jurors are programmed and police are programmed and everyone is programmed. And you ask me, how do you get a hold of me? And I'm so programmed, I give a phone number, right?
All right. Well, with that, we got to wrap it up. Thanks, Mark, for coming down. I think this has been an awesome episode of Lawyer Talk. And again,
I had a great time.
Anybody who needs help, they now know who to call.
Thanks, Steve.
Yeah.